All right. So this workshop is part of the Open Access Week workshops that are being offered across the UC system. So I'll be talking a little bit today about things that are specific to UC Riverside, but also a lot of this will apply more generally as well as to folks across the UC system, since we'll be talking about some UC policies in particular. This slide deck was adapted from a workshop, Copyright for Grad Students by Authors Alliance, which is licensed CC BY 4.0, and we will talk about CC licenses a bit later. So I'll introduce myself. My name is Rachel Starry. I am the Digital Scholarship Librarian here at UC Riverside Library. Again, these slides are available. I had popped a link in chat, but for folks who are wanting to follow along or kind of come back to this, reference any of the links and resources shared in this workshop, you can access those at bit.ly/UCR Library -copyright 2021, all lowercase. And I have my email here on the screen as well, and I'll share that in chat towards the end when we have time for some Q&A. But always feel free to reach out to me directly, and I'll have some additional contact information and links later on as well. So before we get started today, I do want to take a moment to acknowledge that we are still living through a pandemic and multiple crises. So of course, the pandemic and other structural inequalities have disproportionately affected people of color, particularly Black and Indigenous peoples. So as a member of the UCR community, I stand with Black Lives Matter and AAPI communities against racism, xenophobia, and human rights violations. I also want to recognize our responsibility to the original and current caretakers of this land, water, and air here in Riverside, California, the Cahuilla, Tongva, Luiseño, and Serrano peoples, as well as their ancestors and descendants, past, present, and future. And while we're currently meeting digitally, I'm located in Riverside, and I do invite you all to learn whose ancestral lands you're physically located on. One place you could do that is on the screen here at native-land.ca. So definitely for today, do whatever works for you all. Feel free to engage in whatever way you're comfortable. And again, I hope you'll reach out if you have follow-up questions. So today's presentation has 5 parts. So we'll start by covering some of the basics of what copyright is, what copyrights you have in your work. Then we'll look at incorporating works by other people into your writing, including works that might be in the public domain, that might be openly licensed. We'll talk a bit about relying on fair use, although that's very complex, as well as securing permissions and licenses for works. Then we'll talk generally about options for depositing your work online, both dissertations and theses, as well as more broadly scholarly work. We'll talk about a couple of things to consider when you're signing a publication contract, including some points you might want to negotiate with publishers. And finally, we'll just very, very briefly look at a way or two for you to manage your scholarly identity online, because that ties into sharing your work online and sharing your research more broadly as well. And a lot of what I'm going to be talking about is academic writing and research focus, but it will kind of be more broadly applicable. And if folks have kind of other cases other sorts of situations you're involved in that are kind of tangential to, or other areas of academia, happy to kind of take a stab at answering questions about those as well. So hopefully the goal is by the end of the presentation, you'll have a better understanding of what copyright is, how to use copyrighted material in your work, and some of the ways that you can manage your own copyrights. And I have a slide at the very end with references for all of the images that I'll be using today. Another kind of caveat up here at the top, I'm not a lawyer, I am a librarian, so I'm not able to offer legal advice. So this workshop is sharing kind of factual information about US copyright law to the best of my ability. But again, it does not constitute legal advice. Always recommend folks, if you have a legal question, reach out to counsel. So I have some links here for more general information about copyright at UC. The best starting point is the UC Office of Scholarly Communications Guide to Understanding Copyright. And I have that linked on screen here, but if you search, it's also at osc.universityofcalifornia.edu, and you'll be able to find on their drop-down menu all their copyright information. Another fantastic central resource is the UCOP copyright site, which is just copyright.universityofcalifornia.edu. So again, I'll take a stab at answering folks' questions. I'm kind of local support here at UCR for copyright questions, but more advanced questions can always be directed to this email address, copyright@ucop.edu. So let's get started with a general overview of what copyright is, what it protects, how long it lasts, those sorts of details. So we'll be talking today specifically about US copyright law. Of course, other regions and countries have their own legal frameworks, but we can only kind of really talk scope-wise about things published in the US today. So the source of copyright law in the US is originally the Constitution. So Article 1, Section 8, Clause 8 of the Constitution gives Congress the ability to pass laws to incentivize authors and creators by giving them a kind of temporary monopoly, a period of time during which they can profit from their work. And so in this phrase here, which is a quote, to promote the progress of science and useful arts by securing for limited times, this phrase here is important, limited times, right? It's a nod to the kind of value of works eventually being free for the public to use and build on. And again, we'll talk about kind of duration and specifics in a second. So the current copyright law in the US is the Copyright Act of 1976. And this protects original creative works of authorship that are fixed in any tangible medium of expression. So today, copyright protection is automatic. In the past, under previous iterations of copyright law in the US, you would have to do things like register your copyright with the Copyright Office or display a mark, a copyright mark on your work. None of those formalities are required under current copyright law. So the act of just fixing your original creative ideas in some kind of tangible form is enough to invoke the protection of copyright. So fixing a work means that it is written, saved, painted, otherwise created in some medium that is not ephemeral. So this can be writing on a cocktail napkin or saving something to the hard drive of your computer. Those all kind of count as fixing it. And original works, there is a kind of minimal, fairly low bar for creativity. Courts have held that almost any spark of creativity is enough to kind of constitute sufficient originality. And some things are barred from being protected, but on the whole, most original works that you write down are protectable by copyright. And again, so while you're no longer required to register your work with the Copyright Office in order to secure copyright, again, it's automatic, there are some benefits to doing that. So on the one hand, if you pay a small fee and submit your record to the US Copyright Office, that will serve as a record of ownership, which can be helpful if somebody wants to find out who owns a given work in order to ask permission to use it, for example. Registration's also required if you want to bring an infringement lawsuit against somebody else for using one of your copyrighted works. And if you register in a timely manner, there are then eligibility for statutory damages and attorney's fees in the case of an infringement lawsuit. If you don't register your copyright, then you could only actually collect actual damages. Typically, again, if you're working with a publisher, they will also assume responsibility for filing on your behalf, but that would be outlined in your contract, which we'll talk about later. So with a couple of exceptions, including something called work for hire. If you're writing something at the behest of an employer, you will, of course, generally own copyright in something simply by being the author of that work. So what does that mean? What does that give you? Essentially, copyright is a bundle of exclusive rights that only the copyright holder can exercise. They can also authorize somebody else to exercise that on their behalf. Rights can also be transferred or assigned to other people. But essentially, the exclusive rights guaranteed under copyright are the ability for the copyright holder to make copies, but also to make derivative works, things like translations or abridgments, as well as the ability to distribute, publicly display, and publicly perform the copyrighted work. And that includes in all different media, so online as well as print mediums. So, by holding the copyright in a work, authors, of course, prevent other people from exercising these rights. Of course, that's what makes them exclusive. And again, as I mentioned, it's important to kind of note that in publishing contracts and license agreements, folks like publishers will sometimes ask authors to transfer or assign rights away, as opposed to licensing. So later on, when we talk about publication and negotiating publishing agreements, we'll kind of talk about how that works, ways you might want to consider what rights you want to retain. So under today's copyright laws, copyright lasts for a very long time, largely thanks to the lobbying efforts of the Walt Disney Company. As a general rule, and of course this is under the Copyright Act of 1976, for works authored on or after January 1st, 1978, when that law went into effect, if the work was written by an individual author, copyright's now the lifetime of the author plus 70 years. For works made for hire or anonymous and pseudonymous works, that's a little bit longer. It's 95 years from the date of publication or 120 years from the date of its creation, whichever expires first. This is already sounding very complex. And of course, copyright law has changed over time in the US. So 1976 wasn't the first time we had a copyright law on the books. So if things were published prior to that year, then they were governed by whatever copyright law was in effect at the time. So these calculations can actually get really tricky. And I mention this because it's really important to kind of note this complexity when you're going out and looking at the legality of reusing particular kinds of works. It can be in some situations quite difficult to determine whether copyright has or has not expired, depending on when something was published, depending on who published it, where they published it, all these kinds of details. One handy calculation, though, for calculating in particular when things for sure are entering the public domain, even under, kind of taking into account historical copyright complexity, as of 2021, works published in the US with a copyright mark on them before January 1st, 1926 are now in the public domain. And I have a link here to this specific section of copyright.gov, the copyright title code, if you're interested in reading more. Again, it's complicated. For folks who are kind of publishing now, though, as kind of authors now, it's a little bit more streamlined. It's just 70 years plus the lifetime of the author. Copyright law is not unlimited, though. And in fact, there are certain things that just are not eligible from the get-go to be protected by copyright and are automatically in the public domain, which I'll define in more details in a second. These include things like facts, data, calculations, things like just the distance of the Earth from the sun. Nobody owns that fact. It can't be copyrighted. Similarly, things like lists of ingredients, rules of a game, things that might be able to be fixed in form, but are not sufficiently kind of original or creative. That said, the way that facts and data are expressed, how they're articulated in a book or an article, the way that like ingredients and lists of ingredients are assembled into a cookbook, how the rules of a game are assembled into a rules booklet. Those things are copyrightable. So additionally, works created by the US federal government or by federal employees in the course of their job duties are not eligible for copyright. Those are automatically, they belong to everybody. Although that's not true for works by foreign governments or US state governments. And then some things like titles, phrases, and slogans are not copyrightable, but they may be subject to other kinds of intellectual property law, which brings us to this slide. So there are things beyond copyright laws that do protect different kinds of intellectual property. So trademark law governs those things like slogans and logos. Patents can govern processes, methods, systems. And of course, companies might have secret formulas or recipes that are protected trade secrets. There are different kinds of intellectual property law that protect different kinds of things beyond copyright. So UC copyright policies govern the ownership of works created by UC faculty, staff, and students. And in fact, 2021 was the first time that we saw, I believe since 1992, an update to the UC policy on copyright ownership. So I have a link to that, the full text of that policy here. There were several reasons for the update on that policy. Of course, they wanted to align with current copyright law and language around that. Fun fact, copyright law is changing yet again. There's another act that was passed in 2020 that's going to essentially form, because up till now, only a judge could decide, could determine and could rule in fair use cases, for example, or other kinds of copyright infringement cases. But there is actually going to be the formation of a small claims court for copyright. So kind of stay tuned for how that's going to affect UC folks. There's a lot that's kind of still up in the air as it's being implemented right now. I also have a link here to an FAQ about the 2021 policy. This is a really excellent resource. Again, this is on the Copyright UCOP site. That's where all the policies can be found. There's also a 2015 policy on copyright and fair use. This essentially outlines how the UC is going to, back up folks, employees who, in the course of their job duties are using copyrighted materials in good faith in what they believe is a fair way, according to the fair use doctrine, which we'll talk about. So that's here for reference. And then another one to kind of be aware of is the 2003 policy that updated the original 1992 copyright ownership policy. And this is specifically, this outlines, how instructors at UC own the copyright in course materials that they're producing. So this screen here, or this image is kind of a shorthand way of outlining where copyright is retained by UC authors versus where it might be retained by the university. So the key distinctions to note are under the 2021 copyright ownership policy, scholarly and aesthetic works created by academic authors, which doesn't include all UC employees. In those cases, copyright is retained by the author. Under the 2003 policy governing course materials, that states course materials, except this case of course approval documents, ownership is retained by instructors. Course approval documents are essentially, and you can kind of refer to the full text of the policy, but that's essentially the documents that are submitted kind of through academic senate procedures that govern course approval. So things that are printed in the catalog, like the course description, learning objectives, some of the details that might be included in the syllabus, like the course outline. The university retains a non-exclusive license to continue using those materials to run that course in the future, but the copyright is retained by instructors. Students retain copyright of their works. And of course, if an employee prepares a personal work outside the scope of their employment, they of course retain the copyright in that. The only time where it might be governed by a written agreement or where the copyright might be retained by the university is in the case of sponsored works, commissioned works, works that are created with exceptional university resources, which is of course defined in one of the policies or more than one of the policies, those sorts of things. And if you're not an academic author, so for example, I'm a librarian, I am part of that group of academic authors because research, instruction, and publishing are kind of core parts of my job duties that I'm expected to do and I'm evaluated on. So my scholarly and aesthetic works, along with faculty and instructors who are part of this academic authors group, we retain the copyright of our works. But if, for example, I create a report, or if an academic author, is writing an institutional work like a committee work, like a report, that sort of thing, then copyright is normally retained by the university. Are there any questions so far? Because that's kind of a lot in terms of ownership of your own copyright, this whole copyright at UC, how that gets determined. Feel free to ask questions in chat if there are any so far. And if not, also feel free to keep throwing them in chat and I will definitely address them as they come up or at the end. All right. So we can move on then to using third-party material in your work, things that you did not create, what options you might have for reusing other people's material legally. So again, in terms of how copyright law is outlined in the United States, with some limited exceptions, the copyright owner is the one who can is the only one who can exercise their exclusive rights. So there are several strategies though for legally reusing third-party material in your works. And these are the kind of 4 main ways that you can do that. So the first is by using public domain works. The second is using openly licensed works. You could also rely on the fair use doctrine to reuse copyrighted material, or, I'm sorry, in the absence of those 3 options, if those aren't an option, you can always get a permission or request a license to reuse copyrighted material in your works. So the first one, and I've been using this phrase already quite a lot, public domain. Public domain is just the commons of material that is not owned by anyone, that is not protected by copyright. Anyone is free to use, copy, share, and remix works that are in the public domain. And I should clarify, public domain is a really specific US copyright doctrine. And it also doesn't mean anything that is publicly available. It is really specifically materials that copyright doesn't apply to or copyright has expired for. So several ways that things kind of get into the public domain. So works when the copyright has expired and was not renewed, those materials enter the public domain. Again, things published after January 1st, 1926, unless Congress intervenes and something changes again, every year that's going to push forward so that more things are going to enter the public domain as their copyright expires. Again, we talked about formalities. So if copyright owners failed to comply with formalities when they applied, so things like needing to register with the Copyright Office or display a mark, those were required up until, some of those were required up until 1989. So if copyright owners failed to comply with those, then their work might enter the public domain after an initial copyright period expired. But unfortunately, there's no easy way to kind of detect or to search for whether something, whether those copyright owners did or did not comply with the formalities. So really it's safest to assume works published after 1926 are copyrighted unless you can definitively determine otherwise. Again, some things are simply not copyrightable in the first place, and authors can intentionally choose to release their work into the public domain. That's called dedication. And it is one way. It's irreversible. So once you say as an author, I no longer want to own the copyright in my materials, I want everyone to be able to benefit from them, done. That's done. Yeah, it's just one directional. But that is an option, and a lot of folks do choose to do that with their works. So if something's not in the public domain, there's another option in terms of reusing third-party materials, and that is if that work has an open license on it. Creative Commons licenses are the most well-known public licenses, but there are others. So if you see a CC license on something, that means that the author has made the decision to allow, kind of preemptively, give permission for folks to reuse it in particular ways and to limit the reuse of that material. It's important to pay attention to the specific terms of different open licenses. We'll talk about what some of the different CC license options are later when we're talking about, applying it to your own work. But essentially, if a work is made available under a public license, like a Creative Commons license, then that work can be used in ways that comply with the terms of the license. Which brings us to fair use, the most complicated section of this workshop. And I'm seeing some questions in chat that I will certainly address. So fair use is essentially a feature of copyright law that under certain conditions permits the use of copyrighted works without permission or payment. So Congress has stated, in Section 107, I believe it is, fair use of a copyrighted work for purposes like criticism, comment, news reporting, and most kind of relevant to us, teaching, scholarship, and research is not an infringement of copyright within certain limitations. So essentially the reason for the existence of this doctrine, right, is that the cultural value of materials is so high in some cases that while we want to, of course, as a society, incentivize creators and give them control over things that they create for a limited amount of time, we do want to kind of have the ability to allow others to critique that material and to build on it, right? So fair use can kind of be seen as a safety valve that's built into copyright law to prevent copyright from stifling creativity fully. So some classic examples of fair use include, direct quoting copyrighted content in a commentary on that work, such as a book review or other sorts of academic writings, using certain kinds of excerpts of copyrighted materials in course instruction and nonprofit, non-commercial academic instruction, or creating parodies. Those are all things that are protected by fair use. But to decide whether a use is or is not fair, courts have to consider 4 factors that are laid out in the 1976 Copyright Act. And again, this will be changing in the coming years when small claims courts and copyright officers who are appointed rather than judges will be able to evaluate through the same process, evaluating these 4 factors, whether or not uses are fair. So that's something to kind of, again, stay tuned. UC will be providing kind of more information as things change in the realm of copyright. But I do want to kind of just take a few minutes and look through these different 4 factors and talk about them, because fair use is such a fundamental, it's a fundamental thing that we rely on in the academic context as we're researching and teaching and publishing. So the first factor is the purpose and character of the use. So here's where courts ask, is this use of this copyrighted material transformative? Does it add new meaning or expression? Does it add new value or understanding? Transformativeness is not necessarily required. But when a work is used for a different purpose than it was originally created for, this factor will likely weigh in favor of fair use. If, however, you're simply copying without making any kind of transformative changes or adding to the work, that's less likely to be fair. And courts will also sometimes look at whether it's a commercial versus non-commercial use under this factor, but that's less important. And I should say, these are all not applied kind of equally. So factors number 1 and 4 are actually kind of in case law, the most common to be relied upon and kind of the most important. But again, it comes down to each individual case. So I actually have a resource here on the slide. Cornell Copyright Information Center has some excellent resources about fair use. So they have a fair use checklist to kind of walk you through all of these. I love pointing people to this particular resource. So that's factor number 1. The second factor is the nature of the copyrighted work. So here courts consider whether the work was more factual or more creative. So if the work was more factual, like a technical report or news item, that's the reuse of that kind of factual material is more likely to be fair than if you're reusing something that was creative. Under this the nature of the copy work, this factor, courts can also consider whether something was published versus unpublished. Published materials lean towards supporting fair use versus unpublished, which is less likely to be fair. Factor number 3 is the amount of the work copied. And this one has a lot of misconceptions around it. So sometimes you'll hear people say some kind of magic number, like if you reuse less than 10% of a copyrighted work, then that's legal, which is not true. Court has to take into account not only how much, but also kind of qualitatively how much of the original work was used. So courts will look both at kind of, page counts, or if it's an audio visual sort of thing, like the actual, how length of the selection. So quantitative is important, but also qualitative assessment. So courts will look at what is the heart of the work, the essential bit of it that makes people want to engage with it. So if you are taking a small amount in either qualitatively or quantitatively, that's more likely to weigh in favor of fair use. So in theory, copying an entire work could potentially be a fair use, but conversely, even copying a small amount might lend towards disfavoring fair use if the amount that or if the section that you're copying is the core of it. And then finally, factor 4 is the effect on the market, essentially, for the copied work. So again, this together with number 1 tend to be what courts rely on most heavily in doing their evaluations. So essentially, the court will take into effect, kind of, could this sort of use in future cases cause substantial harm if it were to become widespread. So within academic contexts, really we could talk for a very long time about all of this, but there are kind of a few key situations where fair use may apply in academic contexts. So of course, we're familiar with the idea of criticizing, commenting on, discussing copyrighted material in the form of direct quotations in research papers, that sort of thing, or using material that is copyrighted to illustrate a point or support an argument when the absence of, displaying the thing that you're talking about would be detrimental, and you wouldn't be able to illustrate your point without copying something that is copyrighted. The third use case here is a bit less common, but it's becoming more common. So using copyrighted material for non-consumptive research. And I've actually talked a lot about this in the context of text analysis when we've done text analysis workshops. So for example, the HathiTrust Digital Library is an amazing resource, and they have a research center that provides algorithms where you can, as a researcher, non-consumptively work with copyright material. So if you are copying things into a database or doing computational analysis across texts or images, but you're not, reading, displaying, or sharing large portions of the material itself, it couldn't be reconstituted from your data mining or text mining, then there are strong legal precedents for that being a fair use. And we won't get into it too much today, but I did want to just gesture at the fact that there is another exception to copyright law that provides for students and teachers having certain rights to publicly display or perform copyrighted works in the classroom, again, with some limitations. So the classroom exception is, again, very important, and you can read more about it on the UCOP copyright site at this link here on the screen. If a work is not in the public domain, openly licensed, or you do not think that you can make a case for fair use for your reuse of it, then your last option is to seek permission or a license from the copyright holder to exercise one or more of their exclusive rights. So a license is just a grant of authorization from a copyright holder to allow you to exercise one of their rights. So the license will describe which uses have been authorized. And of course, your use would need to fall within the terms of the license, but this is always an option. And I don't have a link to it again here on the screen, but the UC Office of Scholarly Communication, as well as the UC Copyright central page, has recommendations on the process for going about seeking permissions. And of course, if you're wanting to reuse images or things that were published by any of the major academic publishers, they all have guidelines on their website for authors and for folks who want to reuse materials that they published in terms of seeking permission. So in addition to copyright, there are other legal considerations to keep in mind as you're evaluating the use of third-party content in your own work. So clearing copyright concerns does not mean that you have necessarily cleared all other legal concerns, because of course there are other legal issues like privacy rights, rights of publicity, patent and trademark law, defamation. All of these might be legal concerns for the material that you want to reuse. In addition, contractual terms governing access to a work could restrict uses that would otherwise be fair. So a big case for, in the academic context, for this is kind of archives and museums. They will have rights statements and contractual restrictions on the ways that you're able to reproduce materials from those archives or museums. And you'll obviously need to seek permission from the museum, even if it's, for example, a photograph, a historical photograph that is well out of copyright and in the public domain. There's still going to be rights restrictions. This is changing the world of kind of libraries, archives, and museums, is recognizing the importance of making their collections more open, but always look for the right statements when you're doing archival research. And the database and website terms of service are also incredibly important to kind of pay attention to, especially for kind of licensed resources. For example, a lot of the newspaper databases that the library provides access to are subscription resources, even if it's a newspaper published in the 1800s. That newspaper the access to it is controlled by a company that charges libraries for access. And yeah, so basically read the terms of service. And on top of all of that, I have to kind of call attention to the fact that there are additionally ethical considerations beyond the legal considerations that, there are some situations where you definitely would want to think twice about reproducing materials, reusing certain kinds of materials when the reuse carries the potential for exploitation or harm. So I would, of course, recommend just give careful consideration to avoiding things like cultural appropriation, digital colonialism, things like digital blackface, exploiting indigenous knowledge, protecting individuals' identities beyond what is legally, required, such as, minors, but, photographs of protesters, of incarcerated people, circumstances like that. Of course, plagiarism kind of falls into this ethical consideration bucket because it is, it's a harm that's grounded in ethics versus a harm grounded in law. It's slightly different from copyright infringement, but certainly relevant in the academic context. Any questions so far on all of that? And I do ask you a question in terms of how can faculty get help navigating this really complex landscape? So I will have a slide at the very end of this presentation, and of course, you can access it. Let me pop a link again in chat to these slides if you want to access any of these links and resources. So on the library's website, there is the Ask a Librarian option, and there are a number of resources that are kind of sprinkled throughout this that I hope would provide a starting point if you're looking into this, but email is also a great option. So in this section, I just want to talk very briefly about some of the options here at UC for making your dissertation or research articles available in our institutional repository. So the UC has a policy produced in 2020, it's policy on open access for theses and dissertations. So under this policy, because of course UC is committed to sharing research and scholarship conducted at the university as widely as possible, UC requires grad students to deposit theses and dissertations prepared here into an open access repository. And for those to be freely and openly available to the public, although grad students can request an embargo period, and that's just delaying the date that something becomes publicly available. And under extraordinary circumstances where there might be potential for harm or kind of a high legal or safety risk, those embargoes could be extended indefinitely, but that's pretty rare. I recommend this resource here if you have general questions. Again, this is the Office of Scholarly Communications website. I have a link here to the actual thesis policy, but essentially dissertations are at UC are deposited to eScholarship. So this is the University of California institutional repository to make things open access. So there's a lot of benefits to this in addition to kind of the fact that you're complying with policy. So of course, sharing your work in eScholarship preserves it. It makes it easier for others to find and cite it. And of course, you're still owning the copyright. You're retaining the copyright to your materials when they're uploaded to eScholarship. You're just giving the university a non-exclusive license to store it, preserve it, and make it publicly available. And you get an easy link to share your work. And I have a link here to the UCR Graduate Division thesis submission guidelines if you have questions about that process. And of course, this is not limited to dissertations and theses. The UC open access policies enable all UC academic authors to deposit your scholarly publications in eScholarship. There's actually two different open access policies. The first was published in 2013. That applies to academic Senate faculty. And then the other one, the presidential OA policy, came out in 2015, and that covers everybody else, students, faculty, staff, instructors who are not academic Senate. So essentially, and I'm not going to click away just in the interest of time to look at the actual policies, but the idea behind these, the reason they exist, is to kind of preempt, in a way, to allow UC and UC authors to preemptively grant a non-exclusive license to the university to share your work in eScholarship in an institutional repository prior to any contracts that you make with publishers subsequently. So UC retains the rights specified in these policies, enabling you to share your work open access. And of course, there are limitations on this. So for any research articles covered by the policy, you'll need to be careful about which version you upload to eScholarship. So the version is supposed to be the author's final version. That's also sometimes called a preprint. And of course, some publishers do allow, or you can negotiate which version you are allowed to, in the contract, upload and share in an institutional repository. So you could, some publications allow postprints, so the version of the manuscript after it's gone through peer review, and some even prefer you to upload the final kind of formatted version, although others do not permit that. So essentially just read your publishing agreements. But this is really just kind of important to get out there, especially thinking if it's open access week, that all UC authors have the right to upload your scholarly publications to eScholarship. And it's quite simple to do that. So here at UCR, it's even easier because the system called the UC Publication Management System actually simplifies the deposit process. It automatically searches multiple publication databases, and it should send you an email when it finds something that it thinks you wrote. Sometimes it gets things wrong, but you can always manually create an account in the system and upload and manage your deposits at any time. So you can just start here at oapolicy.universityofcalifornia.edu to make use of the open access policies and share your work. And so placing your work in an open access repository, obviously helps make it more available, and it helps readers access your work without those kind of price and cost barriers that publishers often, the paywalls, put on things. But without a CC or similar license, folks would still need to ask permission. So applying a CC license allows you to kind of, go beyond that all rights reserved and preemptively give permission to folks to use your work in different ways. So I just have here a summary of the 6 different licenses that are essentially combinations of different limitations you can place. All of them require attribution, unless you're going for a public domain mark or CC0. Then in all these cases, folks will need to attribute you, cite you. But you can also specify, share alike means when folks create new things based on your work, they have to distribute that under identical license terms. So you can kind of prevent folks from adding additional restrictions in the future if you want to keep things more open, or vice versa. If you just really want to prevent anyone from commercially making use of stuff down the line from your work, you can do that with a non-commercial clause. And then the last one is no derivatives. So just preventing folks from remixing, adapting. All they can do is redistribute, reproduce, or perform a work. So let's move on to publication contracts. So we can't cover everything, obviously, in a publication contract in this particular workshop, but I do want to kind of talk about a few high-level considerations you might want to keep in mind as you're negotiating or signing a publishing contract. So this obscenely bright slide, it's essentially just a mnemonic device to help remind us the importance of the contract. So the acronym is RUNS, the contract runs the relationship. So this is just reminding us to read the contract, understand what it means, negotiate for what you want, and save a copy. And this is just like general good life advice. So why should you care about negotiating the terms of your publication contracts? Well, publishers frequently ask authors to transfer some or all of their copyrights. And of course, whatever you license or transfer determines how you will be able to use your own work in the future. And when publishers ask for a complete transfer of copyright, frankly, that is unnecessary. There are publishers who will disagree with me on that. But in terms of like authors, publishers do not need to own all the rights to your scholarly or creative work to bring them to print or to publish them online. When you do sign away your rights, then you can't exercise those rights if they belong exclusively to the publisher without infringing on their works. Again, just going to be able to scratch the surface today. So the Authors Alliance Guide to Understanding and Negotiating Book Publication Contracts is an excellent resource. The Office of Scholarly Communication also has a really excellent page on negotiating publishing agreements. So that link is here as well. Highly recommend both of those resources. But essentially, there's a couple of things you might want to keep in mind as you're evaluating a publication contract. I mean, the first very bare bones thing is read it and ask for clarification, either from the publisher, from an attorney, or by utilizing the other UC resources mentioned in this workshop. Second is super important to kind of identify and prioritize your goals. So a lot of the times especially with larger commercial publishers, it's not likely that you'll be able to fundamentally rewrite the contract from scratch or retain all rights. That just may not be possible in some cases. So it's important to kind of, think about what are the uses that you would want to make of the material in this work. If it's a book, are there sections that you would want to use in particular ways in the future? Are there learning materials that you would want to use kind of in a fixed form in courses that maybe wouldn't qualify for fair use? Essentially, what are the things that are really important to you to kind of certain rights maybe that you would want to retain? Would you want to have a say in if it was translated or abridged in the future? All of that should be information covered in the grant of rights section of your contract. It's also kind of helpful to keep in mind that negotiation is a conversation. It can be really intimidating to try to negotiate, but it doesn't have to be confrontational and tense. And it is certainly worth asking publishers for any contractual changes that matter to you. And of course, that might take a while, so it might take a little bit of patience and persistence. Again, a lot of things are kind of controlled through the contract. We can't talk about all of them, but in addition to the grant of rights, which is what we've been talking about, which rights do you keep? What are you licensing or transferring and assigning to the publisher? There are other things you might want to consider, right? So what are your obligations for the respect to the work? Sometimes there's fine print in there about royalties or about dates that certain things need to be in by. Pay particular attention to places where you're indemnifying people or signing away any kind of right to arbitrate, those sorts of things. Of course, questions in terms of permission. So who's responsible? Sometimes publishers stand in different places on this in terms of whether you need to seek permissions for all, say, images you want to reproduce. If some publishers are more comfortable, they have a higher risk tolerance in terms of relying on fair use. They can land in lots of different places here, but that's worth asking, worth checking into. Things like who has say over the look and feel, if illustrators are involved, all of that sort of thing. And finally, and very important, getting rights back. So under what circumstances do you want to be able to regain your rights if you sign them away? And there are contracts, or there are clauses sometimes called out of print clauses where it's nice to include something like that in your publishing agreement so that if the publisher goes out of business, if your book goes out of print, what happens then? Do the rights that you have assigned to that particular entity revert to you? Do they go to somebody else? That can be really helpful to kind of consider. Finally, before we wrap up, I just want to take a very quick moment to talk about scholarly identity, because it's kind of related to all of this, and managing that online, streamlining things. And like what I mean by this essentially is, it's helpful to kind of proactively manage your scholarly identity in terms of distinguishing yourself from other researchers. If you're at UCR and you've gotten emails from the UC publication management system, you probably know how common your name is or not. So it's really helpful to have kind of unique identifiers that you can use to distinguish yourself and to increase the discoverability of your work, as well as maintaining an up-to-date sort of presence ensures that folks can find you, that you're able to kind of grow your professional network and connect with people who want access to your work. So it's helpful to ensure that it is widely available. It's one thing to kind of share your work in eScholarship, it's another to make it easy for folks to find you. Discoverability and findability are really separate from access. So my number one recommendation in this kind of arena sphere is to sign up for an ORCID ID. You may also hear it pronounced by its acronym ORC ID, but essentially this is just a persistent digital identifier that distinguishes you from everybody else out there. It's really easy to set up. You can just go to orchid.org, and then that's the first stage. Then you also kind of want to really consistently use it on publications, on grants, other research output, and it's just going to make it a lot easier for all of your work to kind of be associated with you. So I have a slide here that is a kind of resource roundup for UC. Again, the copyright policies, open access policies, a lot of this can be overwhelming. I know there were a lot of kind of rules and, those sorts of things. That's just the nature of the beast when it comes to copyright and all of that. But essentially, what I really wanted to kind of convey in terms of things like the ownership policies and the open access policies is that they exist to, especially the open access policies, kind of aid authors in that negotiation process, in retaining rights to share your work openly, for all the excellent reasons to do that. And then I have a link here again to the UC Office of Scholarly Communications. They have amazing resources for authors around copyright, around publishing, highly recommend checking out their site. And then further resources are available again through Authors Alliance. They are a nonprofit organization that helps authors kind of understand their rights, manage their rights. So they have guides to fair use, publication contracts, open access, and more. And you can find those at authorsalliance.org. So here's the promised slide, and I will stop talking and just look at chat and see if folks have any final questions. Again, you can reach out to me. I'll put my email in chat. And if you would like to do a fair use assessment or kind of just request a consultation and follow up on any of the things that we talked about today, my Calendly link is on the screen to easily find a time to meet with me. And if you just have a general question, definitely check out the library website. We have an Ask a Librarian link. Ask us at the top of the website to request a general reference consultation. And again, the link to the slides is here.